Thank you, Rachel. Good morning. It's so nice to see you all on this webinar. We are so grateful to have the National Immigrant Women's Advocacy Project present to us on U and U visas as a crime fighting tool. This is just another way that we can use to protect victims and to keep our community safe. Today we have two great speakers. The first is Leslie Orloff, and she is the director of the National Immigrant Women's Advocacy Project, which is located at the American University Washington College of Law. She offers training technical assistance to judges, police, prosecutors, and victims advocates. She also advises on legal protections for victims advocates. And in her 38-year career, she has done tremendous work on behalf of victims of crime. She helped to draft the Immigrant Protections for the Violence Against Women's Act. She has advised the Department of Homeland Security. She's published numerous law and social science journal articles and has served on a number of national committees, including committees related to the Immigrations and Customs Enforcement Committee, advising them as well on victims' rights and on immigrant victims' rights. Officer Shelley Sonnenberg is a graduate of University of Idaho, and she has served the community as a law enforcement officer for 22 years with the Boise Police Department. She currently serves as a community outreach officer, and she oversees, as the community outreach officer, she oversees in the liaison program with the resettlement agencies. She's also a crisis negotiator, and in 2006, she was the Officer of the Year. She also oversees the interpreter and translation department the interpreter and translation section for her law enforcement agency. We are so grateful to have them today. And so without further ado, I'd like to bring you Leslie Orloff and Shelley Sonnenberg.
Thank you, Charla. We're very happy to be here, and hope you learn a lot today, and want you to know that this is the first of what we hope will be several of these webinars. So we can provide more detail as we go forward. Well, first, we want to thank the Office of Violence Against Women at the Department of Justice, who has supported the development of this webinar. The opinions and what you're going to hear today belong to me and Shelley and Detective Sonnenberg. So thank you for joining us. Back to you, Charlotte.
So here are our learning objectives. By the end of this webinar, you'll be able to identify which victims qualify for the UNT visa, hold offenders accountable by utilizing immigration relief as a crime-fighting tool, enhance victim, community, and officer safety by combating domestic sexual violence and stalking, and then implement pretrial and trial strategies to meet common defenses in cases involving immigrants of crime. So, who do we have in the room today? We have set up a poll: law enforcement, prosecutor, systems-based victim witness staff, judges and court staff, or E, community-based victims advocates or attorneys. I'll give you a couple of seconds to answer.
Almost everyone's participated, so
Okay.
Just another second here and I'll close it out. There we go.
Okay, so the majority are systems-based advocates. We have some judges and court staff. Thank you for joining us. Community-based victims advocates, law enforcement, and then the second highest category is prosecutors. Thank you all for joining us. We hope you enjoy this presentation.
Yeah, so this is Shelley. Before we get started, I apologize that I am not on screen. Our department doesn't allow us to have cameras, so I do apologize for that, but thank you guys for letting me be here to talk with you a little bit about this. We wanted to give you a quick update and give you some caveats on how we're going to make this discussion work today. Obviously, men, women, and children can qualify for the U visas, and victims of almost all violent crimes and many other crimes are eligible for the U visa. We're going to get into specifics a little later. But as we speak throughout today, oftentimes we're going to refer to the female victims of domestic violence and sexual assault. But we do understand and recognize that men, women, and children do qualify for these crimes or qualify for these U visas.
So when we talk about U visas, it's important to understand, so today we're actually going to be talking about U visas and T visas. We're going to include some information about human trafficking. And what you can see here is these are the criminal activities that fall within the U visas. And this data comes from a survey I did, but over the years we have, our numbers are quite similar to what the Department of Homeland Security has been seeing over the years. And that is about 75% of the cases, U visa cases filed nationally, end up being domestic violence, sexual assault, child abuse, and human trafficking related. And human trafficking victims can file either for a U visa or a T visa, or the case can start as a U visa and then become a T visa. And that was all designed. But the other kinds of criminal activities also include, you know, felonious assault and kidnapping, blackmail, extortion. We'll go over that. But to give you a sense of what that looks like. So the other thing that's really important to understand is that Congress over the years, starting in 1990, has passed a series of laws designed to protect crime victims and victims in particular of domestic violence, child abuse, sexual assault, and human trafficking. And so the reason, and this is a very good tool, it'll be in the materials we give you because, I'm not sure if you can see my screen if I do this, but these little boxes here, these, if you click on the black circles, that will take you to the forms on the Department of Homeland Security website. If you click on the word U visa, it will take you to the web page at the Department of Homeland Security that describes the U visa. So we're going to be talking today about T visas and U visas that are for crime victims generally and for trafficking victims. But I also want to mention two other forms of relief that are important for you to know. And that is that in cases where the perpetrator of domestic violence or child abuse or spouse abuse is a US citizen or a lawful permanent resident, that spouse or the abused spouse or immigrant spouse or child could also qualify for something called a VAWA self-petition, which is a much easier case and much quicker case to get. And it doesn't require a certification from law enforcement or prosecutors or courts, like we're going to be talking about later today. So you may see cases, anytime you have a case, the red flag is if there's a family member who's a US citizen and it's a parent, step-parent, or over 21-year-old US citizen child, let's say in an elder abuse case, those cases can be VAWA self-petitions. And we have lots of training. We did a national webinar on that we can connect you with. Rachel, can you take notes on the things I'll say we'll connect them with to make sure I have a list at the end? Would you mind?
Yes, ma'am.
Okay, so the VAWA self-petitioning webinar will connect you to in case you're interested in learning more about those cases. The other thing that's really important to understand is that when you're working with children who've been abused, any child who's been abused by their parent, one of their parents, not both, it doesn't have to be both, but one or both of their parents, anywhere in the world could qualify for special immigrant juvenile status. That's that SIJS one on here. And so particularly if you're thinking about a case in which mom and the child are abused by the father, let's say in the United States, those cases, both the child and mom could qualify for a U visa, but that U visa process, as you will see today, is going to take many years. The child, within 6 months to 3 years of filing, if they're abused by their father, could also file for special immigrant juvenile status, while mom will continue with the U visa, the child could get relief through special immigrant juvenile status. So again, the red flag for that is just knowing anytime you're dealing with a case where the child has been abused by a parent, that could be a special immigrant juvenile status case, and I want you to be aware of that.
Okay, so this is where the interaction part comes in, you guys. We want to ask and poll you guys on why is immigration relief available for crime victims. So if you will post your chat in the chat box, is that what we want them to do, Rachel?
Mhm. Yes, ma'am. For this one, please use that chat box.
So why is the relief available?
To ensure victims are available to come to court, help prosecute, both good suggestions. Anybody else? To ensure that crimes are reported and victims don't fear deportation, victim protection, because deportation is a threat used against victims. To build relationships between law enforcement and the undocumented community. Yep. Provide additional protection and services. Shelley, over to you.
Yeah, excellent, you guys. I don't know why I'm teaching this. Obviously, one of the issues that we have with the immigrant populations is they often are targeted. And regardless of whether or not they're undocumented or not, one of the things that we as law enforcement need to do is protect everybody who lives within our community. If we don't know that the crime is happening, how are we ever going to protect those people, and especially those that are most vulnerable? So the legislative intent was specifically so we know what's going on in our communities. The victimization of this particular group of people is like at the very, very top. So our job to assist in putting the bad guys in jail can only happen if we know that there are bad guys out there. So you guys mentioned the community policing, that the reporting the crimes. Oftentimes, oftentimes what happens is that one person is not the only person that the suspect has victimized. So it continues to work with us in other aspects of just that one victim, and we're preventing anything more from happening. So that's kind of where that came from. And to put it in a graph form, that's kind of what it looks like. Every so often you hear the terms, we had, community policing come in and out with law enforcement for many, many years. We're getting back into that again, especially here in the Boise area. We need to have that open communication with the people who are living here in our areas. So by allowing this relief, they feel more comfortable coming forward, then we can have the prosecutions and we can keep everybody safe.
And what's really interesting before I get to the International Association of Chiefs of Police resolution is that Congress in the legislative history wrote that one of the explicit purposes was to build better relationships between law enforcement, prosecutors, and immigrant communities, because they understood that those were harder to reach communities, and the goal was to give law enforcement and prosecutors and the courts a tool to build relationships. And what's really interesting is we've done some social science research over the years, and what we found is in communities where police, prosecutors, and courts are signing U visa certifications, signing T visa declarations, in the court context, issuing special immigrant juvenile status findings, where that is occurring, those send a signal essentially and provide a building block that improve community relations in those communities with the justice systems entities we're talking about. And in those communities, we are, even in times when anti-immigrant sentiment goes up and fear of deportation is greater, we're seeing that in those communities, immigrant victims continue to come forward. So it's a great way to build, they're great crime fighting tools. And that's what International Association of Chiefs of Police recognized, that they're both significant crime fighting tools and that they encourage police department leadership to get involved in the kinds of education and training on the programs, the T&U visas that we're doing today, and that these visas protect not only the individual victim, as Detective Sonnenberg said, but also have many times U visa victims come forward and then they report other crimes in the future, or the crime they report initially may lead to the discovery of other crimes. So IACP recognizes that it improves this police community cooperation. It's a way to build, these programs are ways to build trust between law enforcement and prosecution officials and immigrant communities, and they provide an opportunity to increase collaboration with the victim advocacy groups. And victim advocacy groups, the community-based victim advocacy groups in this context play an important role, because one of the other things we see that social science research has told us among immigrant victims is very few victims come forward to use the courts or call police or prosecutors without the assistance of a victim advocate. They often learn from someone in the community that they can approach the justice system. And so victim advocates can play a bridge role essentially in these contexts. So I'm going to talk very quickly about a little bit of some of the dynamics of that immigrants experience who are victims of domestic violence, sexual assault, and human trafficking and child abuse. And one of the things that we have found over the years, and I'm sure this isn't surprising to any of the victim advocates or the prosecutors or law enforcement on this call, on this webinar, but immigration-related abuse is a significant power and control, coercive control tactic that is very effective, that perpetrators use to essentially silence immigrant victims and try to keep them from reporting the crimes that they're suffering, which is part of their vulnerability. And that can include refusing to file papers. So under immigration law, a family member can legally file, or an employer could legally file papers for somebody who works for them. And sometimes people do not file papers, particularly in family context, purposely to maintain power and control. And sometimes they'll file them and threaten to withdraw them. And then you see, as you guys noted in the chat, lots of kind of threats of deportation, threats to turn people into DHS. And what we found is, this is actually the top part of this slide, is the original data we took to Congress in 1994 when we were writing the Violence Against Women Act. And what we found was when a US citizen or a lawful permanent resident is married to an immigrant spouse, almost over 70% of the time that they could file papers, they don't. And that when they do file papers, there's a mean delay of almost 4 years, which demonstrates how they're using immigration-related abuse. And the NIJ research that was done by Kent State found that in 65% of the cases involving immigrant survivors, you have this kind of power and control dynamic. But what's also important to understand is that it also affects the lifetime abuse rates. And so you have higher lifetime abuse rates among domestic violence and child abuse rates among immigrant families where there is a marriage to someone who could control the immigration status of the other person. So it's a US citizen and lawful permanent resident. We've seen similar things where work visa holders can bring their family members and the like. And when we look particularly at US citizen spouses or former spouses married to immigrant women, or, to immigrant spouses, the abuse rate jumps to almost 60%. And so that power control plays a big role. The other thing that's important is to understand is that immigrant girls and young women are particularly vulnerable to sexual assault. The study that was done by Decker and Raj and Silverman in Boston looked at all high school girls, and they found in this Boston school system, and they found that foreign-born girls were twice as likely to have suffered sexual assault by high school than their non-immigrant peers, and often multiple incidents of sexual assault. And then the research was also done and found that Latina college students were particularly at risk compared to other college students for attempted rape. And so as a practice tip, the things we really want to encourage you to do is really screen for immigration-related abuse, because one of the things that we found is, I'm going to be dating myself, Charla revealed that I've been doing this work for 38 years. When I started training law enforcement in particular, we would talk about the cut telephone cords. You arrive at a scene and then there's a cut telephone cord. And that we all know to be a symbol, a symptom of domestic violence. Well, this immigration-related abuse, it turns out, coexists with physical or sexual abuse and may predict escalation of abuse. It doesn't exist to the same extent. It's like 10 times higher in relationships where there's physical and sexual abuse than in relationships where there's only coercive control and emotional abuse. So it's important to understand that this is not benign if you find these facts happening in your case, and you want to document them and look to identify whether physical and sexual abuse may also be occurring. Back to you,
So let's talk. Yeah. So let's talk a little bit about what prevents immigrant victims from reporting crimes and also participating in the investigation and prosecution. If you guys will write some of your responses in the chat box, we'll talk a little bit more about that. I know the interactive part again. So the language barriers, the cultural barriers, the fear of police, of deportation, lack of trust in the system, absolutely. Fear of retaliation, yeah, good ones.
Right, the not being connected to the communities, or maybe they're in their communities and afraid of immigration consequences, or have been told that it's not safe to talk about it outside of the community, or the shame that somebody's talking about as well. Yep.
Not having trust in the system.
And kind of not being sure how the system works. It's really true. Part of our rules is to help people understand how our system works, because how the system may have worked in their home country could be very different.
Yeah, so with the immigrant victims, we have the fear, the misconceptions, the barriers, the same that we have when we're dealing with DV victims or sexual assault victims who have been born here. But when immigrant victims come from another country, the struggle is they have additional misconceptions, fears, and barriers. And you guys, really hit on a lot of those already. But to talk a little bit about some of the other issues is, as Leslie said, sometimes they're ostracized in their own community. We talked about the retaliation, the deportation, and the threat of that. I have had many victims that have had their documentation, any documentation that they had withheld from them, the threat of taking them away from the children, of turning them in themselves. So we talk about the fears of just a regular victim, and then add on somebody who knows that they're undocumented and it can be returned back to their home country, which might not be a very fitting place for them to be. You also have the misconceptions that you guys really hit on already, but that lack of the trust of police. Me working with the refugee community, I mean, that's a huge barrier for us to get over, just to open up that communication. Not knowing what the laws are here, I have to teach them about domestic battery and sexual assault and child abuse. These are things that don't necessarily exist in some of the countries where we have refugees arriving from around the US. Some of them have family members that come over that don't return home, that are then undocumented, and their struggles into letting them come forward and share their story because they're afraid of that deportation. So there's a lot of corruption outside of the US when it comes to law enforcement. I'm sure some of you think that there's some corruption in the departments right now with everything that's going on, but that's heightened tenfold when you go to some of these other countries. So we have to overcome some of those things. You guys mentioned that they don't even know how the system works or have trust in the system. And probably the biggest issues are the barriers, which many of them don't speak English. How are they going to come forward if they're not able to communicate with us? They're dependent on the suspect. There's isolation and family, religious pressures. I mean, all these things add into, and this is before they even make the step to come forward and share their situation and are identified as actual victims of a crime. So when all of this is happening and you add all this, if we don't provide that immigration relief, we're not going to have them come forward. And the only way that we can have them come forward is if we're opening up those lines of communication. This is a real hot topic for me, and it's something very close to my heart because there are responsibilities as law enforcement officers that we need to create that bridge and get over those barriers. So language access here in Boise, this is just how we do it. We actually created an interpreter program. So we have interpreters that are able to come forward and assist us in our investigations. There's way too many things that are missed and skipped when you're using an interpreter that's informal. You're using the child, you're using the neighbor. We need to make sure that we are doing things per the justice system. And one of the things that we have to do is to provide that equal and fair treatment. And if we don't understand what the person's saying, it's impossible for us to do. So when you talk about, why it's important, these things, the medical records, the counseling records, the police records, all those things, if we aren't interpreting them correctly, how do we really know that we're helping the person? I've had so many cases where the interpreter was either not qualified or not certified. Even using bilingual officers have caused problems for us in misinterpreting and leaving information out. And so when we get to court on it, the prosecutors are kind of put in a really bad position. And what a lot of agencies don't know is that per Title VI of the Civil Rights Act of 1964, anybody who is receiving federal funding assistance is required by law to provide an interpreter to somebody who does not speak English. Really, really important for us to know that that's our responsibility. It's free of charge for them. If they don't ask for it and you know that they need it, you have to provide it. It doesn't mean that we have to reinvent the wheel. As you saw on the previous slide, medical records, counseling records, school records, there's a lot of agencies in your area that are using interpreters so these things can be done. We tapped into the interpreters that were already being used at the hospitals, the schools, the court systems, but we made sure that we were providing that language access piece to overcome that barrier with our victims. So just be aware, the Department of Justice can investigate you if you're not providing that service to the victims that you're helping and working with. And we can go into that more, this is kind of a basic 101 class, but that's how I got my department to start working with language access, is the threat of them being, investigated by the Department of Justice for a civil rights violation. I love my home. I'm not going to lose it because I didn't take the steps that are actually required by law to provide. So just be aware of that. Specifically with the U visas and when they come forward, there's some things that need to be considered, but we're not going to be able to communicate with that if we don't have that interpreter there sitting in with us. So let's get into the U visa and talk specifically about that now that I kind of get off my little high horse there. So the U visa grants the victims a 4-year stay, which allows us as law enforcement and prosecutors to get our case put together and make sure that we have a victim that's still here when we do go to court. I know that before this happened, we were losing victims all the time because they were being deported, and then we weren't able to continue with the case and pursue charges against the suspect, who then, of course, went out and re-victimized. So there's only 10,000 U visas awarded per year. I will tell you that there's a backlog. Where are we at on that right now, Leslie?
I think it's 111,000 or 115,000. It's a long backlog. But the good news is that, the first point of that people get some real protection upon filing, and then they get formal protection from deportation and work authorization. It's running about 4 to 6 years right now. So we have to, from a victim advocacy perspective, there's a real challenge to think about how you can stabilize victims and what tools you have during that kind of adjudication waiting process.
Yeah, and it's just so important to make sure that we're getting that in as soon as possible so they can get on that list. And I understand with the backlog, it's quite frustrating, but if we're not taking care of them, they're not going to come forward. So it's our responsibility to assist with that. So it does require certification that, go ahead, Leslie.
Yeah, I just wanted to add that it's particularly during that wait period where things like orders of protection, things like, getting custody awarded to the victim, where the family courts really can play a very important role in trying to help stabilize things in the family so that the criminal case can also go forward.
Yeah, absolutely. And because the process is set up in such a way, just because the application goes in, it's important for y'all to know that that's not where it ends, that there's additional documentation that is required. And we're going to go through all of that with you and kind of give you the background as to what the process is today.
So this is kind of what I alluded to. So the first part of the process is the victim has to get a certification from a government official. We'll talk about who can give those certifications. And once the victim does that, they then put together their immigration case. They're usually about this thick, lots of documentation and paperwork. Once the case is filed, the Department of Homeland Security puts that case in a special, what they call red flag system, that helps inform immigration enforcement officials about this applicant is a victim. So that if the perpetrator tries to call in a tip that their victim is undocumented, it will help prevent the Department of Homeland Security from responding. And there's something called the Violence Against, and those provisions come out of the Violence Against Women Act confidentiality protections. And those confidentiality protections do several things. One is they they stop the Department of Homeland Security from being able to rely on perpetrator provided information or information provided to their family members. Second thing it does is it helps make sure that locations where victims need to receive services are protected. So protected in locations include shelter, transitional housing programs, victim services programs, courthouses, anytime in connection with any kind of a case related to domestic violence, sexual assault, any of the U visa criminal activities, will show you the list where a victim is seeking help at a courthouse. There's we have a whole training on VAWA confidentiality that we can give you, but since we have so many prosecutors on these calls and victim advocates from prosecutors' office, the other part that's really important here, because it has implications for criminal and family court discovery, is that there are very strong non-disclosure provisions, so that Department of Homeland Security, Department of Justice, Department of State are barred from disclosing to anybody the existence of what happened in, or information about, or papers contained in any file, U visa, VAWA self-petition, or T visa file. And sometimes many perpetrators, and we see this has been on the rise recently, will try to use criminal court or family court discovery to do an end run around this. And again, in a more advanced training for prosecutors and judges, we can provide, and family lawyers, we can provide more information on this. But the long and short of it is that all that might be discoverable is the U visa certification itself, where the certification happened by a police officer, a prosecutor, or a judge. Other than that, it's not discoverable. The rest of the file isn't discoverable. And so the rationale for these protections has to do with the fact that we see that between 25 and 38% of perpetrators of crimes against immigrant victims, particularly domestic violence, sexual assault, and human trafficking and child abuse, are actively involved. Like once the victim files the U visa or T visa or VAWA self-petition case, the perpetrators are actively involved in trying to get DHS involved in removing the victim from the country. And so that's why these provisions, why the U visa was created, and why VAWA confidentiality protects. The other thing for law enforcement and prosecutors to be aware of, and this goes back to what Detective Sonnenberg was talking about a few minutes ago, largely often because of language access problems, what will happen is when victims call for help for the police in a domestic violence or child abuse incident, what we're seeing is that 36% of the perpetrators are actually able to get the victim arrested or arrested with the perpetrator. And many times that happens because of lack of language access to crime scenes. And so, but on the other side, the good news about this is that we also know that once VAWA self-petitioners, T visa and U visa applicants file their immigration case, they have higher future crime reporting rates, and they're more likely to be willing to turn to the justice system for help in protection orders in family court cases. So the initial cert and getting a U visa started or a T visa started plays a big role in being able to solve other crimes in the future, because these victims often come forward. Back to you, Shelley.
So here are the requirements, and I'm going to actually go through these with you guys, and we'll talk in more depth about them. But we need to identify what qualifying criminal activity occurred, and if it is within the criminal activities that qualify for the U visa. We need to make sure that the victim possesses information about the crime, and that the activity occurred in the U.S. or violated U.S. law. The only caveat to that is that also can mean like an Air Force or any type of military base that can fall within this as well. We also need to determine whether or not they're being helpful, and that means has been, is being, or is likely to be helpful in the detection, investigation, and prosecution, conviction, or sentencing of the crime. We're gonna, what the heck does that mean? I get that all the time, okay? We're gonna go into depth about what that actually means too. And then the third requirement is whether or not they sustained physical or mental abuse as a result of the crime that was committed. So those are the specifics that we're looking for with the requirements, and the crimes themselves, as we talked about before, are most of the violent crimes that exist. Did you need to say something, Leslie?
No, I'm fine.
Oh,
But we did
okay.
have a question pop
Um,
up if you wanted to.
Oh, yes.
Okay. So
Sure.
someone asked, there are some prosecutors and offices who do not certify U visas supplement B forms for fear of it coming up in trial, and the defense is using it against the victim. Can you speak to that and how to help address U visas in trials? Or we can come to this later. I was just letting you know there was
Absolutely.
one
So
there.
let me just tell people that we actually do have kind of an overview section that we're going to be talking about this issue a little bit later in the presentation. We also have a whole series of training tools for prosecutors to help prepare to, to address this. And I think using the methods that we're going to be talking about later today, prosecutors have been very successful in actually getting better outcomes in the prosecution by not putting off the certification than by waiting until afterwards. And we can talk about that more. But yes, we will absolutely address that, I promise.
Yeah, and a really good question, because it's something, even from a law enforcement standpoint, that used to worry me quite a little bit. So Leslie has a great section that we'll talk about that in more in depth. So as you can see, most of these, there are some things that, might stand out a little bit more. The felony assault. So we don't have felony assault here in, listed that way in Idaho, but when you're filling out the form, the description of what that is can be used. So even though you might see some of these that don't actually exist in your agencies or in your states, the reasoning behind the criminal activity is what's most important. We don't have a false imprisonment one, but we know what that means. So just those are the ones that specifically we're looking at. I'm not going to go through all of them because they're sitting right there for you guys to view yourself. But be aware, there's quite a few that qualify for a U visa when you have a victim that comes across your desk or comes into your office.
One of the things that we'll talk about in future webinars when we kind of go and dig into the certification form, and that it's really important. Detective Sonnenberg was talking earlier about, detection, investigation, prosecution, conviction, or sentencing. So it's important when when you think about this, is you want to, in filling out the certification form or for the U visa case, identify everything you detect, because sometimes you might detect more crimes occurring in the relationship or in the in the workplace context than the ones you choose to prosecute or that you have a successful criminal investigation regarding. The other thing that's important is to understand that not only is the direct victim of the domestic violence or sexual assault or human trafficking covered by the U visa, but there can be some indirect victims. So for example, when you have a child abuse victim or somebody who's incompetent or incapacitated, or if you have a murder or manslaughter case, a family member would be an indirect victim. So the mother of the child sexual assault victim, you might have a child sexual assault victim who's a US citizen, but their mother is undocumented, and their mother might be here on a student visa. So one thing to note about U visas is it helps both people, it helps anybody that doesn't have a path to lawful permanent residency. And that includes both people who are here legally on various immigration visas and people who are here undocumented. And so the idea is to allow the parent or the guardian to come forward and help with the investigation or prosecution. The other thing that happens is that there are a few limited cases where you might have a bystander who's an indirect victim. And I'll give you an example from the U visa regulations. This was a real case that occurred actually in Virginia. So there was a birthday party. So there was a domestic violence case. The parents had split up. The following year, the child had a birthday party, and it must have been summer because it was out on the front lawn. And the father came along with a gun and tried to kill the mother at the birthday party. He ended up shooting somebody else, and there was an attendee at the birthday party who was pregnant. And the person who was pregnant wasn't actually shot or shot at directly, but she could be an indirect. She ended up miscarrying as a result of being at the shooting scene. And so she was able to be an indirect victim, even though of the U visa, because she suffered substantial harm, which is the miscarriage, or it could be PTSD or other kind of trauma from having been present during the shooting. That's generally how that works, or as far as the U visa goes in that direction. So we were talking earlier about certification, and we're going to talk a little bit. So there's a range of people. When we wrote this statute, we included a range of people as potential certifiers, and it includes federal, state, and local law enforcement. That's local sheriffs, local police, state police can all certify. The FBI can certify from a law enforcement perspective. Also prosecutors. So it could be state's attorneys, local district attorneys, the whole range of people who prosecute cases. Also judicial officers. So judges, magistrates, commissioners, other judicial officers who have authority to make decisions that rolls down essentially from the Supreme Court. And, but also people that are agents, the agencies that investigate child abuse and elder abuse can certify, as can state departments of labor and the EEOC. So any government agency that has any kind of civil or criminal investigative power could be an agency that certifies the U visa. And so picking up on what Detective Sonnenberg said earlier about helpfulness, we're going to give you kind of here a little bit more, this graphic helps you understand a little bit more about it. So helpfulness, it's somebody who has been, is being, or is likely to be helpful in any of these things. So it's detection or investigation and or prosecution and or conviction and or sentencing. It's or, because some people might get involved at the conviction stage, or might get involved at the sentencing stage, or might call and report a crime and help people detect it, or file for a protection order, which helps the court detect it. There's various different ways to be helpful. Let me turn it over to Shelley. Oops.
So in determining what helpfulness is, it's important to understand not only the or, but it doesn't have to be somebody called in and helped detect the crime and followed it all the way through to the end where there was, prosecution and sentencing. So we're going to break it down a little bit so it makes a little bit more sense. So the certifying agency, in my case, it's Boise PD, we're the one who determines the helpfulness. There's not a certain degree of helpfulness that is required. I get these U visas sent to me from legal aid, immigration attorneys, Catholic charities. They come across the desk, and ultimately we decide whether or not we're going to certify based on, as simple as it is, even a 911 call. And to speak a little bit, without going too much into what we're going to talk about later with the prosecution aspect of things, somebody calls 911 to report a crime. Do you think they're calling 911 because they're thinking, oh, hopefully I'm going to be able to apply for a U visa? Half the time they're not even aware that there's a U visa out there that's available to them for assistance. So we'll talk about it later, but just consider just that 911 call. Do I now know that a bad guy lives at that house? It gives me the opportunity to go in and possibly stop crimes from not only being currently committed, but crimes in the future. So the agency, in our case, any agency she just described can complete the certification. investigation can still continue, the sentencing can continue, and the victim oftentimes will wish not to continue in the support of the case. How many DV cases have we had where the DV victim has decided that she doesn't want to help anymore because for fear of all the things that we talked about before? It's not unusual, even in regular DV cases, let alone, you know, U visa cases, that they might stop participating in the case itself. So consider that. Worst case scenario, if they really just are not participating and you get to the point where you think that they're, you know, whether it's, you know, perhaps they lied, perhaps, you know, there's been an issue with the case or whatever, we always can revoke it. It's always an option for us. But it's really important for you to understand how simple it can be to actually be helpful in these cases. For example, as I said, the 911, but look at some of these. Allowing photographs to be taken. How are we going to prove the case if we don't have the photos? Testifying, obviously, is what we ultimately want them to do, but that doesn't mean that they have to follow through with all of this. I have a real hard time explaining this to my officers because I feel like they're vouching for the victim and they don't know enough about him or her to actually vouch for them. That's not what's happening here. It's as simple as those 3 or 4 things that we went over. Did the crime occur? Were they helpful? And was it a qualifying crime? And I'm so sorry.
Did it occur in the United States?
Totally spaced. And it occurred in the United States. Totally spaced that. Sorry, Leslie.
No problem.
So just be aware that, I mean, this is what helpfulness looks like. It can be any of those things. It can be all of those things. So when you get that and it comes across your desk for evaluation, please consider the fact that we now know that there's a bad guy out there and we have an opportunity to go and stop him. So the things that are not required, and I brought up, oh, go ahead, Leslie.
Yeah, I just want to say that for the judges and court staff on the phone, as on the conference call, on the call as well, it's important to understand that helpfulness could occur because somebody came to court and got a protection order, or somebody brought a child to a child welfare case. You know, there was a child welfare case and they brought the child, they took them to participate in interviews at the Family Child Advocacy Center. Maybe it was a contested divorce or custody case, and they revealed the domestic violence and the child abuse and provided evidence. All of that is sufficient, even if they never called 911.
Yeah, and that's true. How often have we had cases where a domestic violence victim has come forward and we find out later that there's also child abuse that's occurring? So we kind of are able to find the other bad acts that are occurring in the family as well. So just consider these things. It doesn't have to get to the point where there's a conviction. It doesn't have to, the offender doesn't have to be arrested or prosecuted. Just knowing about that, we have to consider that, and it's sitting right there, but the victim-centered approach is how we address these U visas. We're helping that victim and providing them a service and an option to help them stay protected. So I've had some of these where it's gone all the way to trial and sentencing, and I've had some that stopped with a phone call to 911. It honestly depends on each situation and that victim coming forward and letting us know that a crime has occurred. So, and so for when we get the certification, you look at what the criminal activity is and whether or not it's a qualifying crime. You identify the victim or the indirect victim, as Leslie explained earlier. You determine the helpfulness. You identify any family members that were implicated in the crime as well. As she even explained with the daughter and the mother, that is an opportunity for the mom to receive a U visa as well. And then obviously note any of the injuries They're going to provide you with a lot of documentation when they send the certification. It's your job also to, in my case, I usually get the information from the report and include that. This form is very, very simple for us to fill out. So I don't want you to think that it's overbearing, but it's important that we identify when we have a victim that would benefit from the U visa, and not always is it going to come from, like I said, legal aid, Catholic charities. Sometimes we're the ones who identify that this is a person who's available for a U visa. And as law enforcement, I want that guy to go to jail. If I can offer something to the victim and I can keep her here for 4 years to make sure that that happens, I'm going to do everything I can to make that happen.
And it's really important, actually, let me just say that one of the reasons they had asked you to identify in the certification form who the family members implicated in the crime are is because they want to be sure, they want to know who you can help essentially DHS understand who the perpetrator is and whether there's a family relationship. So it is important. And the other thing is that injuries, the certification form has an opportunity for people to to note the injuries, but it's ultimately the victim who has to prove it. Certification has to be included. They can't even file if they don't get a certification. So you could have, and that's where, delaying signing certs becomes dangerous for the victim because the perpetrator is out there trying to silence her. And this is one of the ways that she can gain, or he can gain, the confidence they need to be able to continue participating. And once they file, then DHS will adjudicate the full case. This, I know, is a little hard to see, but this is the timeline for the whole U visa case. And what you'll see is that the Department of Homeland Security very early in the case takes fingerprints. And then they run background checks at various different points throughout the case. So there's lots of checks and balances in the process so that, and at each time, the Department of Homeland Security has the discretion to deny the case if let's say somebody has a history with criminal activity. I'm looking at a question. I know. In terms of judges signing U visa certifications, judges can sign certifications in a variety of different contexts. So let's take a protection order. If a victim came to court and got a protection order, even if it was a temporary protection order for a limited period of time, there are judges, some of our judicial experts who do training on this will, if in fact, let's say the evidence before the court when the person came to get a protection order is that they already called the police for help or they're working with the police. In that case, even if the judge doesn't follow through on even if the victim didn't follow through on the protection order, the judge who saw the police report could sign based on the police report. But if the victim never had any contact with the police or prosecutors, only sought a protection order, and then they didn't follow forward with it, then there's a question of whether or not they unreasonably refuse to provide information. And so certifications can happen when somebody took one step, when they didn't complete all of the steps, if the certifier believes that in the context of that whole totality of the circumstances in the case from what they know of it, that the victim might have been intimidated, et cetera. And I'll explain more of that just a little bit later, and I can provide you information on it.
That's a great segue for this question though. So when should you certify? We're going to ask you guys to also enter your answer into the chat, but do we immediately upon receipt? Once your agency has knowledge of victim's past or present helpfulness or believes the victim is likely to be helpful? When you are certain the victim will testify at trial? And when the defendant is convicted? So give me your thoughts on that.
We're just given people a few more seconds to answer it. I see the answers coming in, and I will share that in just 1 second. I'm just watching that number tick up, so I'm giving you a few seconds.
Okay.
Anybody else before I close it?
Leslie almost helped you guys in cheating at this one.
Just making sure. Okay, I'll go ahead and end this now.
Yep, that's what I was kind of expecting to see. So yes, B is the correct one. However, I understand the thought process specifically with A, because I think that we're teaching this class and it comes across that we want it. Yes, I mean, as quickly as possible, once you've verified that they have, you know, been helpful, that the crime that occurred is qualifying, and that there has been substantiated harm in some way, then I would say, yes, do that. However, it is for us in this particular question is when your agency has the knowledge that the victim's been helpful. And the only way you can do that is after you've received the certification to basically verify that they're falling within the qualifications and requirements of the U visa.
Exactly, and so there is, meaning that doing it sooner rather than later is great, but you don't, just because somebody asks for a certification doesn't mean you'll be able to certify, because you might not be able to determine helpfulness. Most importantly though, the part about substantial harm, you do not have to assess for certification. That's the victim's obligation to prove to the Department of Homeland Security later. And we wrote it that way because we understood that, you know, bruises and things like that are gonna, you know, develop over time, and that we wanted certification to happen as early as possible. So we're gonna do one more. We're doing 2 in a row. Make sure you're totally awake for the last part of the webinar. So the question is, why would a U visa victim seek certification from a state court? And so you have 4 choices. The only justice system contact they had was custody, a protection order, civil employment case, or child welfare case. Second choice is there was no language access at the scene when she called the police for, or he or she called the police for help. And the third would be that the judge observed victim's attendance and participation in a criminal case, or all of the above.
And we'll give that a couple more seconds. I see those votes coming in. Anybody else? There we go. Saw a few more pop up. Okay.
That is correct. All of the above. There are lots of different ways that reasons that judges can be certifiers. And so it could be any of those reasons. It could be that the judge observed attendance in a civil case or a criminal case or any of these kinds of cases. Great. So now what we're going to do is I'm going to give you a very brief overview just so that you know kind of what a trafficking victim visa looks like in addition to the U visa. The trafficking victim visa is a 4-year visa for victims of severe forms of human trafficking. The trafficking has to have occurred in the United States, and the person has to be in the United States on account of trafficking. Doesn't mean they had to have crossed the border on account of trafficking. People could have crossed the border lawfully or unlawfully and ended up in a trafficking situation where their movement is somehow restricted. They have to be willing. Now, this is a different standard than U visas. They have to be willing, it's a higher standard of cooperation actually. They have to be willing to respond to reasonable requests for cooperation with an investigation, the investigation or prosecution of the trafficker, unless the victim is under 18 years old, or unless they can show that there's a trauma exception, that the trauma they suffer is interfering with their ability to cooperate. And they have to show that they would suffer extreme and unusual hardship if they return to their home country. It gives them, and it's got a quicker path to lawful permanent residency. So after 3 years in the visa, or when the prosecution ends, whichever time is shorter, the victim can apply for lawful permanent residency. And there is no backlog on T visas. So it's very important to, if you work with victims and you can identify that they qualify as, a victim of human trafficking under federal law, or state, that they apply for a T visa, because it will avoid the long backups we were talking about with the U visas. So you have to have an act of recruitment, enticement, harboring, transportation, advertising, maintaining a person, with physically keeping them. That could be, I worked on a case once where people went to work and the employer locked the doors from the outside once people were in, and they never knew when they were going to be able to leave the employment. That is maintaining somebody. Patronizes, solicit, and benefits financial or receives anything of value. That's the act. There has to include force, fraud, or coercion. And for sex trafficking, it would have to be that the purpose of all this is a commercial sexual activity. Similarly, it also covers labor trafficking, where you have to have recruiting, harboring, transporting, providing, obtaining. Again, securing, obtaining is like, again, think of the locked door from the outside that somebody can't get out, or somehow other controlling their movement. The act could be financially or benefiting or receiving something of value. The means, again, is force, restraint, fraud, threats, coercion, a scheme or plan intended to cause the person to believe that if they didn't perform labor, something would happen to them. And then the purpose is involuntary servitude, peonage, debt bondage, or slavery. That they're actually getting something of value, and that it's happening involuntarily. And we have large charts I can send you if you're interested on how these trafficking, labor trafficking in particular, lines up with some of the state labor trafficking laws. So the application process, this process is running about 12 to 18 months right now. It can be faster, but you identify a victim. Once you identify a victim, the victim might qualify for something called continued presence. And that continued presence is something that if you are a local prosecutor or local law enforcement officer, you can ask your federal law enforcement colleagues to request on behalf of a victim you're working with. If you're a court, you might want to ask one of your state or local prosecutors or law enforcement officials to make that request on behalf of a victim you've identified. And there's really good tools available from the Department of Homeland Security to describe continued presence. The reason it's important is it can happen very quickly, and victims can get continued presence, which gives them access to work authorization and federal public benefits while the case is proceeding. So it's a really good thing to identify. A victim may or may not receive continued presence, but then they can apply for a T visa, and they provide the supporting, they get a T visa endorsement. You do not have to have the endorsement to file the T visa. You can file without it, but it's a very helpful piece of evidence that law enforcement prosecutors and courts can provide. Generally speaking, human trafficking will include force, fraud, or coercion. All states now have human trafficking laws in addition to the federal statute, which I just described. And just like, and that force, fraud, or coercion, usually, unless it involves a child or somebody who's using the trauma exception in the statute, has to be present in all of these cases. And that what happens is it's important to understand that there's a difference between smuggling and trafficking. Smuggling is transportation. Somebody might have paid a smuggler to enter the United States. Once they got to the United States, if that smuggler locked them in a house, didn't allow them to move, and sexually assaulted them, that could be trafficking. It also could be a basis for a U visa. Trafficking, though, is exploitation. But there's a difference between the two, and it's important to be aware of that. And that something that starts as smuggling can evolve into trafficking. There's also particular venues where trafficking can occur. Shelley?
Yeah, and this is specifically for my law enforcement officers to consider. When you look at where these victims are identified, this is where I'm seeing it here in the Boise, Idaho area. For us specifically in the agriculture, landscaping, hotels and restaurants, we had massage parlor issues a couple of years ago. And when we went in and did, for lack of a better word, a sting, we went in and found that many of the women in there had been paying off a debt for coming over to the U.S. and were put in a situation where they were working within the massage parlors to help pay off that debt, which they were never going to be able to pay off. So when we're out out on the street and we're dealing with some of these victims, recognize them as such, recognize them as victims. We don't have any brothels or anybody working the street here specifically, but we have a ton of people that are online and working in the massage parlors, the strip clubs. I just want everybody to be aware that sometimes they're not going to come forward because they're not going to know that this assistance is even available to them. So oftentimes I find out from maybe my victim witness coordinators, or I find out from somebody else that the whole story, that they're undocumented and that we can offer this to them, but also be aware that you can offer it too. If it comes up in your investigation and you're able to identify that they're an undocumented immigrant, offer some assistance with that as well.
Great. And I see there's questions in the chat. I'm going to finish up this trafficking part and talk a little bit about helpfulness and definitely get to the answers of those questions as we present. So these are some labor trafficking statistics that I think are useful to think about. You can have labor trafficking of both men and women, adults and minors, people single and married, it's about the same. Many have children. Many are college educated or higher. So average age is 33, and many victims of human trafficking, particularly labor trafficking, are in the United States legally. I think what I'm going to do is present the next section, which gets to a little bit more details on helpfulness, and then we will absolutely get to your questions in the chat. So I want to explain just very briefly that what happens is that we talked about helpfulness for purposes of certification. And helpfulness for purposes of certification is helpfulness, either they've been helpful. As police and prosecutors, you're usually going to see people who have been helpful at some point in time, either in the past or currently being helpful. And it could be in any of those phases: detection, investigation, prosecution, conviction, or sentencing. What happens is once somebody files, there is another requirement that gets imposed. And that's about ongoing assistance and cooperation. So under the regulations, when somebody files, they have an ongoing obligation to assist law enforcement and prosecutors in the investigation and prosecution, should there be one going forward. But there's an exception that they can show that if they didn't cooperate, that their failure to cooperate was not unreasonable. And the reason for that is that and so the reasonableness, there's two parts of it. Is one, the requests for assistance that happen after filing from law enforcement and prosecutor have to be reasonable. in the context of what prosecutors or law enforcement might normally do with a domestic violence case or a sexual assault case. That immigrants need to be treated as any other victims in those types of cases. Then if a victim doesn't cooperate, the regulations require that you evaluate that failure to cooperate. So this kind of goes back to the question that we got about from the judge and somebody, let's say, who didn't follow through with a TPO, for example, or a full CPO after a TPO. There are reasons why victims do that or not, and you'd have to assess both for the helpfulness part, but also for continuing cooperation part, whether the refusal was unreasonable. And so there are, first you're going to look at the reasonableness of the request. So you want to look at, will the request endanger the victim or family members or witnesses? Does it subject the victim to greater harm? Is there trauma that you need to be considering? So they're going to look at, DHS will look at this, whether or not the request was reasonable. And you should too, in light of what might be happening in the totality of circumstances in this case. And then this ongoing assistance happens. There's an opportunity there's a requirement that they provide ongoing assistance through the point of lawful permanent residency. So this could be years in a U visa case. So for example, if they took a rape kit and then it got tested and 10 years later, the rape case is going forward, they would be required to provide ongoing assistance in that case unless they can show that they didn't unreasonably refuse to provide assistance, and they can, whether or not the request was unreasonable. So have you ever, we're going to do a raise of hands this time, mix it up a little bit. How many of you have had a case of domestic violence or sexual violence where the victim later became at some point uncooperative?
Raise your hands, but keep your hands raised so we got the right count. And it's going up. It's at 15, 17, 18, 20, 24.
Flying up there.
It is. It's creeping up. We're at 29.
So it looks like
30.
Yep, about half of you, more than half of you. Okay, that's great. That is true. We know that victims go back and forth. And what's really interesting is that there can be reasonable reasons to, to refuse because of danger. Maybe the suspect locked the victim up in the house so they couldn't participate. Maybe they weren't aware of the request. The address was wrong. Maybe they're being intimidated or threatened. They believe that participating would put them in danger. All of those are reasonable refusals. And so a victim can go forward with their U visa, can get certification, and continue with their case, and then has an opportunity at the adjudication of their case to prove to the Department of Homeland Security that if they didn't cooperate, their non-cooperation wasn't unreasonable given the totality of the circumstances. So it is very, it provides some real flexibility that is very much kind of that realistically reflects what victims go through. So now what I'm going to do is before we move into the last section, which really does focus on these issues that come up, particularly some of the training work that we could do and some particular issues for prosecutors. What I'd like to do is answer some of the questions. And the first one is, can you speak about a certifying agent? There is a lot of different kinds of law enforcement prosecutors, court judges, child welfare, adult protective services people. A lot of different government entities can certify. They're authorized to certify. There's a question that says that their agency waits until the case is finalized. I'm going to be talking about why that may not be a good idea in terms of the successful outcomes in the prosecution in a moment. And that's what the next section is going to be focusing on. Good question from Victoria Hughes about if you're a DA's office, can you certify if the case hasn't gotten to you yet? The answer is yes. Any certifier can certify. A police department can certify after the case has gone to the prosecutor. A prosecutor can certify if they have the information when they haven't taken the case yet. There are parts of the country, for example, the prosecutor's office, the DA's office in Honolulu does all the certifications for the whole city. People work it out in different ways, but there's no reason, if your agency has the information, like a judge can certify in a protection order when there's an ongoing criminal case. It was designed so any certifier can certify once they have the information and they detect the criminal activity and the helpfulness. Okay to certify. Explain, but did not. Right, so it is okay to certify when you have any level of cooperation. And it may happen that the victim dropped the charges afterwards, but if they came forward and that they dropped them because you believe they didn't unreasonably refuse to cooperate, then you could still potentially certify, knowing that in the end, when she goes to the Department of Homeland Security, if she dropped the charges, she's going to have to explain to them why she did it and convince them in order to get her U visa that she didn't unreasonably refuse to cooperate. So there's a double check in the system. Can the DA sign a request if the cases are? Absolutely. The DA can this DA can sign a request when the case is ongoing, during prosecution, when the case is closed. There's no point in time by which, after the certification happens, after the victim is shown helpfulness, that the certification has to happen. Okay, I'm going to pause there and focus now on some of the primary issues that come up in prosecutions, and then I'll see if we can dig back into if there's any remaining questions. So as I think one of our questioners asked, I mean, when you think of the pros and cons of early certification by law enforcement and prosecutors, the pros are establishing trust, building rapport, protecting the victim from the offender, preventing witness tampering, protecting the victim from deportation. So as Detective Sonnenberg says, they're present during your case, right? The con is accusations, concerns about what the defense counsel may do in these cases. So we have developed a series of tools for prosecutors that helps you think about our main recommendation, and you have one of our national expert trainers in your jurisdiction. You can see her picture on your screen. Charla Jackson is one of our trainers nationally, and she is available as a wonderful resource for you on this, and we will be happy to come back and do a more detailed training for prosecutors. But big picture is it's important to know that, for example, voir dire, you can think about how you deal with voir dire in a way when you know you're going to have an immigrant victim. We have tools on preparing victims for cross-examination, and how we encourage you, and I fervently believe this. I've seen this change. I've been training on this for a number of years now, that as a prosecutor, it's better to be prepared for when the defense counsel is going to raise the issue of the victim's immigration status, and potentially raise it yourself in your own direct examination to take the sting out of it, so that and then prepare your victim for cross-examination. But also what we found is you want to listen carefully. You're actually in a better, let's say you've certified or the law enforcement is certified, and you're expecting, and you've prepared your case so that you're ready when the defense counsel opens the door to this question and says, oh, she is making this all up so she can get a U visa. And what we've done is we've developed a series of tools for you so that you can be prepared for that question and present rebuttal evidence, because what you can do is once they've alleged that the victim has this motive to lie because of the U visa, they've opened the door to you being able to not only rehabilitate the victim, but to bring in all of her prior consistent statements. And you heard Detective Sonnenberg talk earlier today about how, the number of times that a victim who is picking up the call to call for help after a sexual assault or a domestic violence or because of a child abuse case, when they pick up that phone, the likelihood that they actually even knew what a U visa or a T visa was before they picked the phone up is relatively small. which means that you can build your case and prepare to put on your case with a timeline where you can then bring in prior consistent statements that your client, that the victim made before she even or he even knew what a U visa was. It's non-hearsay, not subject to Crawford, and it could be anything that could be offered to rebut or express, rebut and express or implied charge that they were fabricating, and to rehabilitate the victim's credibility. And so I like this visual, because if you prepare your case thinking about this timeline, then there's no reason not to certify early and stabilize your victim, because you have nothing to lose. And actually you have a lot to gain. In the cases where prosecutors are able to bring in prior consistent statements, and Charlotte can hopefully back me up on this, but at least from what I'm hearing from prosecutors using this approach across the country, is that their success rate goes up in their prosecutions. And in some communities, the defense counsel stop trying to raise these issues because they end up losing more when they do. And so it's a really good way to think about being prepared, so that it takes the danger that you're concerned about as a prosecutor away from the equation, because you've planned for it.
I agree, Leslie. I agree 100%. When you plan for the recantation, it helps you to be able to shut down some of those defenses. And over time, they'll stop trying it on that basis because it's ineffective.
Exactly. And so, and it really does, when you think about it, if you make it part of your case, and Charlotte Jackson, and we have other prosecutors around the country who can help us. If you have any questions about how to plan a particular case you're working on, and you want to, so that you're ready for this and you can have the best outcome, that's one of the forms of technical assistance we provide to prosecutors' offices all the time, as well as we provide both prosecutors' office and courts with lots of detailed information about VAWA confidentiality and discovery. Because the fact that you certify and that you turn over the cert to the defense counsel does not open the door that they then get the whole U visa file. Or they can cross-examine about that, but they can't get what she filed with the Department of Homeland Security, which has confidentiality protection. We have even really good Fifth Circuit law on that. And so moving forward, it's really important that, when both law enforcement, police departments, and prosecutors can implement UNT visa certification policies consistent with the law and legislative intent, they improve, and they can use these to improve victim and community safety. As I said, we have lots of materials that we're going to be describing to you, sending to you to help you on more of this. And then we're going to be working with the Prosecuting Council of Georgia on future webinars, so you can let them know what you want to learn more about, and we can provide more detailed training on prosecution strategies, on U visa certification and the forms, on language access, as Detective Sonnenberg talked about. I kind of do that. We provide, training and resources. We have a, I'm going to turn this over to you, Shelley.
Yeah, so if you go to New Apps, we have a lot of information, as she already mentioned, the language access, but just the library itself is very extensive. I'm going to reiterate, I think your best resource is going to be Charla. If you need to reach out to Leslie and I, obviously, we're also willing to assist in any way. I kind of focus on the language access, but Leslie is just a one-woman wonder. So if you guys need help and guidance, please go to these websites and see what you can glean from them. The language access piece, the Asian and Pacific Institute for Gender-Based Violence, great group of people and always willing to assist and pick up the phone, even if they're working from home nowadays. I encourage you guys to put together a language access plan so you know what to do at 3 o'clock in the morning when you get called out from a law enforcement standpoint. If I need a Swahili interpreter, I need to figure out how to find one and quickly. So be aware that we have virtual roundtables. I don't know when the next one is, Leslie, but Charla actually just did one. Go ahead.
I think we have one this week or next. I think this week or next week we're doing one on helpfulness and cooperation. So the ongoing cooperation requirements. So if you want more information about that, we'll be happy to share that. And you can, anybody who works for a law enforcement agency or prosecution agency or court can attend that event.
Yeah,
And
the registration information is down at the very bottom there.
Yeah, and we hold them about every other month or once, sometimes it's monthly, usually it's every other month. We also provide trainings and technical training, all kinds of trainings like these, and we're gonna be working, as I said, to do some more. And we provide individual technical assistance. Wanna describe that a little bit more, Shelley?
Yeah, so pretty regularly, especially from the smaller agencies, you know, Idaho isn't very big. I get called and asked to help them through the process because sometimes they're doing it for the first time, or there's something a little bit unique about a certification that they receive. So ultimately, we are here to help you work through these. Some of the questions that you guys asked earlier, that's why we're here, is to explain the intent behind some of this and help walk you through the form if it's something that you're struggling with. This is a lot of information, you guys. This class is normally, you know, a day and a half long. So I know there's a lot that we didn't cover and there's a lot more information, but we hope to have some of these in the future to work specifically on some of the things that you guys have questions on.
I want to thank you for your time and attention today. I want to turn it back over to the Prosecutors Council and thank you for hosting it today. And we look forward to talking to you again in a future webinar.
Yes, thank you, Leslie. Thank you, Shelley, for both coming on and being so willing to do this webinar. We've had a lot of questions about the UNT visa, so we're thrilled to be able to offer a webinar fully on that. So we appreciate your time. And y'all, Shelley got up super early this morning because she is in Boise, Idaho, so her time zone is different. So she was up very early this morning to do this presentation. So we thank you both for joining us, and we look forward to offering additional webinars on this topic and just to increase our knowledge on it. So thank y'all both.
Thank you. Thank you. We're so happy to have NEWAP do a presentation for us. Thank you, Leslie and Shelley, and you all. Like I always say at all of my webinars and trainings, I'm here to be a resource for you. So please feel free to reach out to me if you have any questions, and I'm happy to help.